Okay, so I love this comment by Karis. Karis says, my issue is that the two lawsuits have effectively been treated as one when they're actually distinct claims. Wayfair brought a defamation action against Blake while Blake brought her own claims. Section 47.1 was specifically designed to deter retaliatory defamation suits against people who report SH discrimination or SA. If someone successfully defeats a defamation claim and is ultimately found to be a prevailing defendant for purposes of 47.1, it seems odd that their ability to seek relief under that statute could be affected by what happens in a separate lawsuit involving the same parties. I just want to be clear. When I say that the whole malice piece needs to be taken into consideration for 47.1, I'm not talking about Blake Lively's lawsuit and her settling. I'm talking about the fact that it was dismissed. Wayfair's case was dismissed, right? And it never got to the place where malice was going to be determined because the litigation privilege was enough to kibosh it. Because 47.1 was for other communications that isn't covered by those privileges. It was supposed to fill in the gap for other communications that didn't get automatically, had an automatic privilege. Unlike litigation privilege, 47.1 is not an automatic privilege. You have to show that you did not do it with malice. It has to be without malice in order for 47.1 to be able to be used. And the reality is the judge never made a determination in regards to malice when it came to Blake Lively. The only one he made a determination on was Leslie Sloan and Ryan Reynolds. And even then, Leslie Sloan and Ryan Reynolds would not fall under 47.1, at least as it's written right now. I also think there's a broader question about how Section 47.1 operates in practice. If courts can dispose of a defamation claim on another ground, such as privilege, without ever naming the 47.1 issue, that could significantly limit how often the statute is actually applied. A law created to deter retaliatory defamation suits may have limited practical effect, of course, rarely need to address it directly. To me, the better approach would be to analyze Section 47.1 question based on the defamation action itself, rather than the overall litigation as a whole, where a defendant has already raised the Section 47.1 claim during the litigation. There is an argument that the court should determine whether the statute applies before closing out the case, regardless of the separate basis for dismissal. Actually, that's something that the judge brought up and said to Michael Gottlieb. And Gottlieb was like, well, we tried to get you to do that. But they didn't before that specific case was dismissed. He never made a determination. Otherwise, the protections the statute was intended to create may rarely be applied in practice. At the very least, it raises questions about how Section 47.1 should operate when multiple related lawsuits are combined, particularly given that the vast majority of all civil cases end up in settlement. At the end of the day, 47.1 was to cover the gap, meaning if somebody said something on social media or other places, before that would not be covered by litigation privilege. And so this was about people who don't typically sue, but are sued for saying something. And they are protected if they get sued because they were not suing them, they were being sued. So I think that's the difference. If people are suing, then they're already protected by litigation privilege.